Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. This is a case decision we'll look at, and let me just describe the case to you and the purpose of doing this video, and then you can decide if this is something that you're interested in, because it's a pretty long decision, and this video, I don't know exactly how long it'll be, but it'll be a pretty lengthy video. So here's the basic setting of this, is we're talking about under the FDCPA, Fair Debt Collection Practices Act, the validation section, so 1692G. And what happened is a debt collector sends that notice to the consumer and they're unsuccessful collecting. So then that debt collector sends it to a collection law firm, which is also a debt collector under the law. And that collection law firm, which we would call the second debt collector, sends a notice, but it does not comply with 1692G and it gets sued. And its response is, we don't have to send a 1692G. Only the very first collector has to send the 1692G notice after the first initial attempt to collect the debt. But the second debt collector, the 8th debt collector, the 28th debt collector, no obligation to send a notice under 1692G. And while they don't make this argument, the court points out what they're saying is that the consumer has no 1692G rights except with the first debt collector. And the court rejects it. And so if you're interested in seeing what are the arguments and how does this court go about coming to that conclusion, it's the first court to make this decision. First appellate court, well, I'll say this, first appellate court to make this decision where they actually discuss their reasoning. And they use a lot of what are called statutory interpretation principles. So how do we interpret a statute? And so it gets a little technical. So if you say, well, I'm not interested in that, then you won't hurt my feelings. You can back out of this video right now. But if you're interested in really the basis of 1692G and how a court goes about interpreting language in a statute that may be a little bit ambiguous, maybe there's two readings of that statute that are both equally valid, well, how does the court figure it out? Then I think you'll enjoy this video. So let's look and see what we've got here. So the FDCPA requires within 5 days of the initial communication with the consumer about collection of debt, must send the consumer a notice, and that's the 1692G. And the question here is whether the phrase the initial communication means first communication from the initial debt collector, or whether it means first communication a consumer receives from any collector, which would also mean subsequent collectors. And here's the conclusion of the court. We hold the phrase the initial communication refers to the first communication sent by any debt collector, including collectors that contact the debtor after another collector already did. In other words, if there are multiple debt collectors that try to collect a debt, each one must send the required notice after its own first communication with the consumer about the debt. And the trial court, the district court, held otherwise, so the opinion was reversed. So Maria stops making payments on the loan. This Thunderbird, a debt collector, sent her a letter. They couldn't collect the debt, so then they retain a law firm to assist in its collection efforts. It sent a collection letter, which was the law firm's initial communication, and it said, hey, we represent Thunderbird regarding this debt, and it informed her she could dispute the debt or request additional information, but did not tell her she could do so only in writing, which 1692G requires it, that the debt collector tell you it must be in writing in order to get certain information back from the debt collector. So the consumer says, hey, you lack the disclosures required under 1692G. So here's the law under 1692G, and it includes a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt is disputed, will obtain verification. All right. So the consumer says failure to notify the consumer that any dispute has to be in writing to obtain verification of it. That violates the statute. And the collection law firms Doesn't even address whether it violated 1692G, which, by the way, it did. Okay, and not the point of this video to explain why that's important, but just trust me on that. It did violate 1692G. But instead, it says we didn't have to send it in the first place because that first debt collector initial communication, that's your only time you get the 1692G language. The district court agreed, grants summary judgment, so threw the case out. And the consumer appeals saying every debt collector that communicates must provide the 1692G notice. So the sole dispute is whether the phrase, quote, the initial communication, as used in 1692GA, refers only to the very first communication sent about a debt, or instead to the first communication sent by each and every debt collector that seeks to collect it. And they say it's divided district court, so those are the federal trial judges. It is an issue of first impression for this court and has not yet been addressed in a published opinion by any of our sister circuits. So this is the Ninth Circuit. They're saying no other court of appeals, federal court of appeals, has addressed this in a published opinion. Now, there's a footnote that would say there's a couple of unpublished decisions, which usually an unpublished decision means there's not very much analysis. And depending on the court, they're kind of saying, look, don't really rely on this. Like, we're not establishing what the law is in the circuit, although that gets a little convoluted. But the point is, nobody has undertaken any analysis in the Court of Civil or the Court of Appeals, Federal Court of Appeals, except for this case in 2016. So they say, look, this initial communication appears, the sentence that appears is ambiguous when read in isolation. When you read in context of the FDCPA as a whole, and in light of the remedial purpose, it's clear that it applies to each debt collector. So start off with the text. Presume Congress says in a statute what it means and means in a statute what it says there. And if the statutory meaning is plain and unambiguous, then the court's role is just to enforce the statute. Just, hey, here's what it says. So when they're trying to figure out the meaning of a statute, they don't look at the words in isolation, rather determine the plainness or ambiguity of the text by reference to the text itself, the specific context in which the text is used, and the broader context of the statute as a whole. So it says, we pursue consistency not only within a particular provision, but also among the provisions of the FDCPA, because what we're trying to produce here is an understanding of the statute as a symmetrical and coherent regulatory scheme, and to fit, if possible, all parts into a harmonious whole. Just saying, look, we're trying to take this big statute and make it fit together and not be contradicting itself. And so if the operative text is ambiguous when read alongside the related statutory, then we turn to the broader structure of the Act and to its object and policy to determine the intent of Congress. And so here's another quote. Interpretation of word or phrase depends upon the reading of the whole statutory text, considering purpose and context of the statute, and consulting any precedents or authorities. And this is sort of a colorful way, but a very visual way of describing it. The words of a statute are, of course, dead weights unless animated by the purpose of the statute. So somebody's pretty clever in their writing there. Okay, so then they say, when we look at the plain language, the structure, the purpose, and that reveals the intent, then we're done. But if the plain meaning of the text remains unclear after consulting internal indicia of congressional intent, we may then turn to extrinsic indicators, such as the legislative history, to try to resolve the ambiguity. So all they're saying is, first you just read the language of the statute. If it's absolutely clear, you're done. If it's not, then you look at the purpose of the statute. You look at what does the statute itself say? Because a lot of statutes will say, here's why we're passing this. If it's still ambiguous when you look at all of that, then you look outside of that. So what did senators and representatives say during the debate process? Were there any reports created? So now you're looking external to the law to figure out the meaning. So statutory text ambiguous, we employ other tools such as legislative history to construe the meaning. So the text of 1692GA does not alone reveal which party's interpretation is correct. So there's no definition of initial communication or initial. Communication is defined as the conveying of information regarding a debt directly or indirectly to any person through any medium. Pretty broad. And they say, look, that's broad enough to get the collection law firm's letter. But here's what the collection law firm argues. They say, look, initial communication is clear. The preceding initial communication, it means there's only one communication because it says the initial communication. And so the debt collection law firm says it was not obligated to send a validation notice because as a second collector, it did not send the very first, the initial communication. And the court says, well, when you look at the initial communication in isolation, you're correct that the word the instead of a or an appears to indicate Congress meant for a single communication to trigger the notice. Then they say, but not so fast. It's not quite so clear when we read in conjunction with the phrase a debt collector that follows in the same sentence. So we don't read things in a vacuum. Congress provided within 5 days of the initial communication, a debt collector must send. So it didn't say the debt collector, it says a debt collector. Suggests Congress may have intended to impose a validation on any debt collector subject to the FDCPA. So a is often used in the sense of any. So I didn't highlight this, but let me just do it now. So in a trademark case, it says a mark or trade name that might cause dilution. So a trademark is, like your company's particular expression or whatever it might be. And so this indicates that any number of unspecified junior marks may be likely to dilute the senior mark. So the fact that it says a mark or a trade name doesn't mean that there's only one. And then everybody else can sort of, copy your trademark. No, the A means any in this. And they say nothing in 1692G limits its application to only the first debt collector. So the collection law firm says, well, Congress's use of the phrase a debt collector could mean that whichever debt collector sends the very first communication must comply. Or, as the consumer argues, it could mean each debt collector must comply upon sending its first communication. And the court says, look, either interpretation is consistent, and therefore it's ambiguous when viewed apart from its statutory context. So, what do you do now? Turn to the broader structure of the FDCPA to determine which initial communication triggers validation notice, the first ever sent or the first sent by any debt collector. And then here's a quote, a provision that may seem ambiguous in isolation is often clarified by the remainder of the statutory scheme because only one of the permissible meanings produces a substantive effect that's compatible with the rest of the law. So we're just saying, if you go, well, it could be either way, let's test that. Let's sort of plug each one into the rest of the law that's at question here and see if both make sense, because usually only one will make sense. And here's what the court says. Makes clear validation applies to each collector. It's the only one that's consistent with the rest of the statutory text, avoids creating a substantial creating substantial loopholes that would otherwise undermine the very protection. So if you accept what this collection law firm is saying, it would create these loopholes that just totally gut this whole part of the FDCPA. And the Supreme Court has told us, you reject an interpretation that would create the problem Congress designed the statute to avoid. That would be ironic, right? Congress says, here's a law to avoid a problem, and then you allow a loophole to just totally make that problem even worse. So Congress used the phrase a debt collector throughout the statute to impose obligations, restrictions on all debt collectors. So here we have the time and place a debt collector. That's not just the first. That's any of them. A debt collector can't talk to third parties about the debt, with certain exceptions. You can't do harassment and abuse You can't lie. That's section 1692E. You can't be unfair. F. None of these provisions contains any language suggesting Congress intended to exempt successive debt collectors from their requirements. And the broad definition of debt collector plainly encompasses those persons who take over debt collection efforts from another. And they say, look, if Congress wanted to say, hey, the first collector has to do the 1692G, but nobody else, they would have just said so. Instead, Congress made it clear the broad reach of these obligations by imposing civil liability on any debt collector who fails to comply with any provision. Well, any provision would be 1692G. And so the collection law firm says, well, we really think that it's only the initial collector. And so here's the first argument. Use of the definite article in the phrase the 30-day period demonstrates the statute contemplated only one initial communication and one 30-day period. And the court rejects that. They say the term 30-day logically refers back to the term 30 days after receipt of the notice, while the notice refers back to the validation notice that must be sent by a debt collector. And so this 30-day period is just the internal reference to other statutory subsections, not the total number of dispute periods. So they reject that. So what does a collection law firm do next? They say that because it says the initial written communication and subsequent communications in 1692E11, 1692E11 is the section that says that it'll sort of distinguish between initial communication, subsequent communication, what kind of sort of disclaimer do you have to give. This is what's sometimes called the mini Miranda about, let's see here, we actually have the text, debt collector from failing to disclose in the initial written communication that the debt collector is attempting to collect a debt, any information obtained be used for that purpose, and from failing to disclose in subsequent communications, the communications from a debt collector. So the point the collection law firm is making here is that there is a distinction between that initial and subsequent. So they both have to say this is a debt collector, but only the initial has to say this is a debt collector attempting to collect a debt, and the information be used for that purpose. And the court rejects that. And they say, look, 1692E11 can readily be interpreted to regulate the initial and subsequent communication sent by each and every debt collector. Indeed, the language supports the interpretation because the fact that it plainly differentiates between initial and subsequent suggests Congress knew how to distinguish between initial and subsequent debt collectors had it been its intent. So the court kind of took that argument, flipped it over and said, yeah, great point, collection law firm. Congress knows what the difference is between initial and subsequent. So if they had wanted to say subsequent debt collectors don't have to comply with 1692G, they would have just said that. So kind of gut them on that. And then they say the collection law firm's restricted interpretation that there is only a single initial communication creates structural problems in the Act. And some district court judges have pointed out that restricting validation notice to the initial collector produces a loophole that would in practice undermine the efforts to verify their debts. And Congress has said if verification is requested, no more collection can occur until that verification has been provided. And we talk about that in other videos. Basically, if you send a request for verification within that 30-day period after you get the 1692G letter, debt collector has three choices. They can verify the debt. They can do nothing. So they never verify it, but they also never collect. Or they could not verify and they could send it to a new collector. And this loophole, what they're talking about is, well, if they chose option 3, they send it to a new debt collector, and now that debt collector doesn't have to give you the validation right. You have no right to request verification. That's just absurd. And so Congress' intent in enacting 1692G was to provide an alleged debtor with 30 days to question and respond to the initial communication. And once they do that, debt collector must cease collection until verification has been provided. And just a little side note, a lot of people think, well, they have to respond in 30 days. No, they could take 5 years. They could do no verification for 5 years. They just can't collect for 5 years until they do that verification. But nothing in the statute prevents the debt collector from passing the debt on to a subsequent collector in lieu of responding to the verification demand. So they have a choice. They can provide the requested validations, continue collection, or they can cease all collection activity. So a debt collector might say it's not worth the effort, and we'll just sell the account. And if they did sell the account, the debt collector that purchased it, if you took the debt collector's, this collection law firm's interpretation, would be permitted to collect free from 1692G strictures, and the consumer would effectively be unable to obtain the information necessary. Such a loophole makes it a nullity, and so we reject that. And that's a principle of statutory interpretation. You don't interpret it so that it leads to an absurd result. And the collection law firm says, well, not so fast. I mean, there's all sorts of things in the FDCPA that would prevent this loophole. And they say, well, what would that be? The collection law firm fails to explain how any of them would allow a consumer to verify and effectively dispute a passed on debt. Congress must have believed that those other provisions were not sufficient. Otherwise, it wouldn't have given us 1692G. Pretty smart argument. So the collection law firm saying, oh, you don't worry about that loophole. The rest of the FDCPA will protect people. Well, if the rest of the FDCPA would protect consumers, why do we need 1692G in the first place? And so it makes it superfluous. And cardinal rule of statutory construction is that we're not going to make a clause, sentence, or word just meaningless. And then the collection law firm says, well, okay, now we got it. We think courts will say, they'll fix this loophole. They'll say a subsequent debt collector found to be in privity with the previous collector must halt its efforts until verifying the debt. Privity usually means there's some type of contractual relationship. You're sort of acting on somebody else's behalf. And they say, you got lots of problems with that argument. It assumes the existence of privity. So there's no assistance when privity relationship does not exist. Furthermore, points to no interpretation of any provision that require courts to hold that subsequent collectors must respect disputes received by prior ones. So this is something that sometimes is annoying to consumers. So debt collector A sends you the 1692G, you respond by disputing it, and then they send it to debt collector B. Well, B is not subject to your dispute and your validation request. Even if they know about it, it doesn't matter because it wasn't directed to them. So they can reach out to you. And what the court's saying is that's actually the law. So why would a court say, okay, well, subsequent debt collector B or C or D or E, you have to somehow take into account and stop all collection until you respond to the dispute validation to collector A. It's nonsensical. So we're not going to interpret statute, create a nonsensical loophole just because courts might be able to apply a common law principle, close the loophole. Rather than doing that, why don't we just keep the integrity of this act? And they say, look, initial communication is for any debt collectors more in keeping with the declared purpose of protecting consumers. So why did they pass this law? Abundant evidence of all these unfair, abusive, deceptive practices by many debt collectors, not a few, not one, many debt collectors. So what was the goal? Goal was to eliminate abusive debt collection and ensure those who refrain from using abusive debt collection practices are not competitively disadvantaged. Okay, we've talked about this in other videos. It's like in a football game. The rules say 11 players on the field, and if you follow the rules, but your opponent says, well, we're going to put 13. Well, now you're at a huge disadvantage. So the FDCPA must be liberally construed and favor the consumer. And so if we look at that purpose of the FDCPA, then it's totally consistent give consumers updated information about their debts and renewed opportunities to verify them as debts change hands. And this is very commonsensical, and then they're going to show their evidence here. Each time a debt is resold between collectors, information may be lost and misinformation introduced. So here's a FTC report on debt buying. Information becomes less accurate over time, making it more likely collectors will seek to recover from the wrong consumer, recover the wrong amount. But it's sort of like an old-fashioned copier. You know, if you make a copy and then you make a copy of a copy and then a copy of a copy of a copy, there's more chance of things fading, of errors being introduced. And so they say records of consumer disputes are among the information that may be lost in the transfer. So the likelihood a debt collector will seek to collect from the wrong consumer or the wrong amount increases. It increases as the debt's resold. So the need for collectors to inform consumers of their validation rights and to respond to requests for verification becomes more needed as the debt changes hands, not less. The collection law firm saying, well, you know, every time it changes hands, you don't need this. No, actually, you need it even more. So they just made an absurd argument, you know, like, I'm telling you, the sky is not blue. It's like we're all looking up going, yeah, pretty sure it's blue. And this collection law firm's like, it's not blue. Trust us, it's not blue. No, it's blue no matter what you say. And then a little bit more, and then this will come to an end here with this court opinion. I say, look, restricting it to the first debt collector would restrict your ability to dispute the validity of your debt, obtain information, and protect themselves against the collection of invalid debts. This because the rights can only be exercised during the 30-day period. So if you believe the collection law firm's interpretation, it would restrict consumers to a single window of opportunity to halt collection efforts. And that would be no assistance to a consumer who later suspects being improperly done or collected by a misinformed successive collector. So let's think about that for a second. So debt collector A sends you a debt, $1,000, and you go, you know, I think that might be right. But before you pay, it's sold to debt collector B, and they send you the same debt for $1,500. You go, well, wait a minute. I dispute that it's $1,500. Well, if you let this collection law firm write the law, interpret the law, which thankfully we don't, then that consumer would have no right to dispute that because, hey, you missed your one chance when debt collector A sent you that 1692G notice, and that's just absurd. And then they say, because the intent to require is clear from statutory text, we don't have to look at external sources, but we are anyway, just to show you there's no doubt. So here's a Senate report. After initially contacting a consumer, a debt collector must send him written notice. There's nothing in here that says it's only the first debt collector or anything like that. And here's the sole goal in 1692G is consumer protection. They wanted it to eliminate the recurring problem of debt collectors collecting the wrong person or collecting debts that had already been paid. It's a significant feature of the FDCPA. And so that's why they added it. And it's nothing that Congress talked about was to minimize the burden on debt collectors. As a matter of fact, they said it shouldn't be any burden at all. And that makes sense because the debt collector ought to have this. And they say, well, the debt collectors are sending this anyway. And so requiring all debt collectors, whether you're the first or the second or the 14th, to send the same required information in their initial communication is consistent because it would provide continuing protection for consumers without disadvantaging an ethical collector. And that's the whole point. Ethical, honorable debt collectors will send the 1692G. The dishonorable ones are trying to, create these bogus loopholes to try to game the system and hurt consumers. And so here's sort of the summary here that I just have in blue. We hold the FDCPA unambiguously requires any debt collector, first or subsequent, to send a 1692G validation notice within 5 days of its first communication in connection with collection of the debt. And in that phrase, in connection with the collection of the debt, we either have a video that's been released or it will be released soon, and so we'll link to it. From the Second Circuit, where it really goes into detail about, well, this letter, is that really an attempt to collect the debt? And so they say, District Court made a mistake in concluding that because the collection law firm is not the first debt collector, it had no obligation to comply. So it's reversed and remanded. So again, pretty lengthy opinion, gets a little technical in there with the statutory stuff. But the value of this is that you really get a great education from this court in what Congress was trying to do with that 1692G language. And we also see that when these debt collectors, and they're always very creative, coming up with just this absurd type argument that if you accepted it would gut the FDCPA, we see here a court going, no, we're not doing that. And let's look at the overall intent of the statute. And so I appreciate you sticking with me and watching all the way through this. And let me know if you have any questions. And if you like these kind of videos, just hit subscribe. We put out a new video every day, and we'll do these case decisions probably 1 or 2 a week. And you should be able to find a playlist that will have all the case decisions. We've been doing these for a number of years, and you might find those interesting. Okay, you guys have a great day. Bye-bye.